Hi there. I hope you're doing well. The purpose of this submodule is to examine the role of the Financial Services Regulatory Authority of Ontario, or FSRA for short. FSRA is the market conduct regulator of insurers operating in Ontario, whether they're provincial or federal. And FSRA is the regulator of insurance products in Ontario. It's an Ontario Crown Corporation that has been created by the FSRA Act. Under Section 3 of that Act, FSRA's mandate in regards to the insurance sector in Ontario includes the following 6 elements. 1. To regulate and generally supervise the sector. 2. To deter deceptive or fraudulent conduct, practices, and activities by the sector. 3. To promote public education and knowledge about the sector. 4. To promote transparency and disclosure of information by the sector. 5. To promote high standards of business conduct. 6. To protect the rights and interests of insurance consumers. FSRA is also the prudential regulator of insurers incorporated or continued under the laws of Ontario. Now, there's just a handful of these insurers, and perhaps this is why the FSRA Act makes no mention of this role. And in contrast, perhaps that's why it makes mention of FSRA's role as prudential regulator of Ontario's credit unions, which is a huge sector and of which there are many. Since the previous module examined the regulation of insurance products, let's examine this aspect of FSRA's market conduct mandate via FSRA's related supervision and intervention powers. These powers are set out in Ontario's Insurance Act, and we will examine the 2 that FSRA uses the most often. 1. The power to issue a cease and desist order. And 2, the power to impose financial penalties. So let's begin with cease and desist orders. Section 440 of Ontario's Insurance Act provides FSRA's CEO, or Chief Executive Officer, with the power to examine and investigate any person engaged in the business of insurance in Ontario, to determine whether they are engaging or have been engaged in any unfair or deceptive acts or practices. Section 439 of the Act prohibits such acts and practices, and the related unfair or deceptive acts or practices regulation, which is actually set out in the recommended readings, prescribe what these are. Not surprisingly, what the regulation prescribes as an unfair or deceptive act or practice is very broad. And it includes, among other things, the commission of any act prohibited under the Ontario Insurance Act or its regulations. From the lens of the regulation of insurance products, this regulation prescribes that the following are unfair or deceptive acts or practices. 1. Any false or misleading statement as to the terms, benefits, or advantages of any contract or policy of insurance issued or to be issued. 2. When rating a person or a vehicle as an insurance risk for the purpose of determining the premium payable for a policy of automobile insurance, misclassifying the person or vehicle under the risk classification system used by the insurer or that the insurer is required by law to use. 3. Dealing in insurance contracts in Ontario without being licensed, which is an act or practice that the Insurance Act itself prohibits. This particular act or practice is illustrated in S&C Insurance Company Barbados, which is set out in the recommended readings. If the CEO believes that an investigated person has contravened the Section 439 prohibition, then Section 441 requires the CEO to follow a due process. That due process involves making a report outlining their findings and provides the CEO with the power to order the person to cease and desist their related activity after giving notice to the person, unless first, that person has requested that the Financial Services Tribunal hear the matter, or second, unless the CEO has chosen to issue an interim order. Now let's turn to the power of the CEO to issue financial penalties. Subsection 441.2 sub 1 of Ontario's Insurance Act states that a financial penalty, also known as an administrative penalty, may be imposed for either of the following purposes. 1. To promote compliance with the Act. 2. To prevent an individual or entity from deriving any economic benefit as a result of contravening the Act. In one of its decisions, the Ontario Financial Services Tribunal states as follows about the purpose of administrative penalty. And I quote, "In order to maintain public confidence in the regulated sectors, we accept that the imposition of penalties by the CEO or by the tribunal acting on an appeal may be appropriate. We agree that in this case it is appropriate to encourage licensees to fulfill their professional and legislative obligations. A general deterrence element sends a message. It sends a message to others that a penalty can be imposed if they do not comply." End quote. Note that subsection 441.2 sub 2 states that an administrative penalty may be imposed alone or in conjunction with any other regulatory measure provided by the Act, including a cease and desist order. Now, there are two types of financial penalties that the CEO may impose. 1. General administrative penalties under Section 441.3 of the Act, which are more serious of the penalties. And 2. Summary administrative penalties under Section 441.4 of the Act. Let's first examine general administrative penalties. Per the Administrative Penalties Regulation under the Insurance Act, the maximum amount of a general administrative penalty is $50,000 for an individual and $100,000 for an entity. In determining the amount of the penalty, Section 4 of the regulation requires the CEO to consider only and only the following 5 criteria. 1. The degree to which the action was intentional, reckless, or negligent. 2. The extent of the resulting harm or potential harm to others. 3. The extent to which the person attempted to mitigate or remedy the loss. 4. Any economic benefit that the person or entity realized as a result of the contravention or breach. 5. any previous breaches of the financial services legislation in Ontario or anywhere else in the preceding 5 years. So from the lens of regulating insurance products, the regulation prescribes that general administrative penalties can be imposed, among other things, for dealing in insurance contracts in Ontario without being licensed. It also includes failure of an insurer to establish a compliance system to ensure its agents comply with their required legislative obligations. And such a penalty can be imposed for charging an unauthorized rate for automobile insurance. From a due process standpoint, the superintendent must give advance written notice of a proposed general administrative penalty, and the person receiving the notice has the right to request a hearing from the Financial Services Tribunal. The tribunal has the power to direct the superintendent to carry out the proposal, with or without changes, or to substitute its own opinion for that of the superintendent. If no hearing is requested, then the superintendent may carry out the proposed administrative penalty. Now let's turn to the other type of penalties, which are summary administrative penalties. The Administrative Penalties Regulation provides for summary administrative penalties for which the maximum amount is $3,000. From the lens of regulating insurance products, the regulation prescribes that summary administrative penalties can be imposed, among other things, for failure to provide a life insured or claimant with a copy of the insurance application on request, and also for failure to deliver notice of intention of non-renewal of an insurance policy. From a due process standpoint, a person is entitled to make written submissions before the superintendent impose a summary administrative penalty, but does not have the right to a hearing before the Financial Services Tribunal. However, the person may appeal the superintendent's order to the tribunal within 15 days after the order is given. To sum up, we have just examined the components of FSRA's market conduct mandate applicable to the regulation of insurance products. We did so via examining the two related intervention powers that FSRA turns to most often. The first is a power to issue cease and desist orders in respect of unfair or deceptive acts or practices. As we discussed, such acts or practices include, for example, dealing in insurance contracts in Ontario without being licensed. And the process to issue a cease and desist order involves due process steps and timelines. The second related power that FSRA turns to most often is the power to issue financial penalties for breaches of Ontario's Insurance Act. And the Act states that an administrative penalty may be imposed for either of the following purposes. 1, to promote compliance with the Act, and 2, to prevent a person from deriving any economic benefit as a result of breaching the Act. And again, as we discussed, there are two types of financial penalties that FSRA may impose. First, general administrative penalties, which are the more serious and costly of the penalties. And second, summary administrative penalties. Not surprisingly, the due process around imposing a general administrative penalty involves more steps and formalities. So this concludes the submodule on FSRA's role as the market regulator of insurers operating in Ontario, including the regulator of insurance products in Ontario. Thanks, and bye for now.